Belgrade Legal Theory Group meeting. We're starting this week with our what is meant to become a regular series of meetings about states of emergency around the world, declared on occasion of the pandemic. Today with us is Pedro Moniz Lopes, who is assistant professor at the Faculty of Law, University of Lisbon, as well as practicing lawyer, a great friend of mine and a great friend of the Faculty of Law, University of Belgrade and of IVR Serbia. His main fields of interest is analytical legal philosophy with a special interest in logical structure of legal norms, though he has recently made some moves towards the dark side of the force by using cognitive science in analyzing judicial decision-making. Most recently, however, he has been vehemently commenting on the regulation and practices of the state of emergency in Portugal. That will be the topic of today's meeting. You're welcome to raise your hands during the talk. You should be able to see in the chat window all the instructions for this meeting, for this webinar. Professor Lopez will talk for half an hour. You can raise your hands while he's talking. After that, I'll give the floor to you to ask your questions, and Pedro will be happy to answer your questions. So, Pedro, the floor is yours.
Thank you very much. Well, it's a very welcoming pleasure to be here, being able to discuss with each and every one of you. It's great to have your invitation, Boyan. I'm very sorry not to be able to be there like I was last year, but so these are the circumstances. I will be very straight to the point in what I want to say regarding this situation that we are all living as it is configured under the Portuguese Constitution. So just to give you a synthesis, a summary of my presentation, I will be briefly speaking to you about the constitutional arrangement in Portugal, how do the division and allocation of powers are structured by the Portuguese Constitution, and then I will focus on 4 topics that are, in my view, being raised under this state of emergency that, by the way, has run its course in Portugal by the last May 2nd. So we are no longer in a state of emergency in Portugal. We are now in a state of administrative calamity, which is a whole different thing. And I will be able to discuss with you some of the discussions. And there are a lot of discussions about what is the difference between the state of emergency and state of calamity. But like I said, I will be addressing 4 topics after I briefly present the constitutional arrangement under the Portuguese Constitution. The first one is something that is rather strange because the first topic is because we all learned about suspension of fundamental rights, or better said, freezing of legal effects of fundamental rights at the university. But we never thought that this would really happen. It never happened in Portugal under the democratic constitution of 1976. So this is a whole new thing for us. So a lot of people are discussing what does it mean to have the legal effects of fundamental rights frozen, because that is enshrined in the constitution, but you have a lot of different views, some of which are, in my view, particularly unsustainable, and that kind of contaminates the discussion, the conceptual aspect of what it means to freeze fundamental rights. That's the first one. Second one is a rather interesting theoretical aspect of the state of emergency. I will claim that under my view of the freezing of fundamental rights, the president of Portugal has some kind of ultra-constitutional or supra-constitutional power to freeze the effects, the legal effects of fundamental rights. This is something that, to my knowledge, has not been addressed in Portugal because nobody was really thinking this would happen. So that's the reason why most likely this was never addressed. The third aspect that I would like to discuss is the scope of the presidential decree that freezes the legal effects of fundamental rights. This is something that has to do with delegation of power and the interplay between the president and the government. It is something, the constitutionality of which is being questioned as we speak by a lot of scholars. So that's also an interesting subject. And the fourth topic relates to what we are living today in Portugal. We are no longer in a state of emergency. We are in a state of administrative calamity. And some scholars are saying something that is rather strange to me as well, that goes like this. If we are not, and this is the argument, so this is a very practical issue, but with a very important theoretical take to it. If we are not in a state of emergency, then we cannot have the legal effects of the fundamental rights frozen. But since we have a conceptual confusion regarding what it means to freeze the legal effects of fundamental rights, for instance, if we confuse them with balancing or restricting the scope of fundamental rights, then this goes into a giant mess. Nobody knows what is the difference, so nobody knows what you can or cannot do under a state of emergency, and conversely, nobody knows what you can or cannot do under a state of administrative calamity. So these are my four topics that I would like to address in my presentation. So first of all, constitutional arrangement. We have, of course, the constitution under separation of powers. That's the overarching principle in the Portuguese constitution. And I will briefly address the scope of the powers of each of the sovereign bodies of the constitution. So we have a president that is elected by the people on direct elections, and he has very broad powers, even though he only used them very scarcely. He has the power to bring down the government, to dissolve the parliament. He has the power to control politically and legally the constitutionality of laws, legally by sending the decrees to the Constitutional Court. And he also has the power to promulgate the laws. So every law that is enacted needs to be promulgated by the president. And of course, he has the power to sign the decree of state of emergency. He has the sole power to sign the decree of state of emergency, provided he is authorized by the parliament and he hears the government. So he is advised on a non-legally binding form by the Portuguese government. So these are the main powers of the president. Then we have the parliament that basically exercises the legislative power by enacting laws, but he's not the sole body that exercises legislative power. The government in Portugal, a semi-presidentialist system, also has the power to enact legislation. But like I was saying, the parliament has the power to enact laws, but also to control the legislative activity of the government, provided certain requirements are met. I will not go deep into that, but there's a certain control that the parliament exercises over the government. The government, on the other hand, has three types of powers. It holds the legislative power. He enacts decree laws, also subject to the control of constitutionality and promulgation by the president. He exercises the administrative power also, so he conducts and controls to the fullest extent the administrative function or power of the state, but he also has very specific political powers. So the government is also an ex libris of the political power of the state. So these are the main features of the constitutional arrangement that we have in Portugal that I think are relevant to what I will say after this. So what happened here? and in a lot of other countries, is that pursuant to the pandemic situation of COVID-19, we had a declaration of the state of emergency by the president. The parliament was authorized unanimously the declaration of the state of emergency. It was renewed twice, and then it ended last May the 2nd. And the government, even though politically he was not very keen on the declaration of the state of emergency, he agreed and he advised taking politically a very friendly view together with the president, even though they don't share the political parties both. But so we had some kind of convergence between president and government to tackle the situation of COVID-19, and that was very helpful on being effective. But so the thing is, it is said that the presidential decree, even though it was signed by the president, it was like a work of art between both the government and the president. There was an arrangement of speaking to one another and trying to find mutual grounds to better and effectively tackle the situation of COVID-19. So the decree was enacted and fundamental rights were frozen. The legal effects of fundamental rights were frozen. We have an article in the Constitution, Article 19, that addresses the requirements that need to be met for the freezing of legal effects of fundamental rights. There are some kind of rights. I will not go deeply into that because I don't want to be descriptive. I want to go straight to the problem. But I need to say this: there are some types of fundamental rights that cannot have its legal effects frozen. And this is even an argument for some people saying that there are higher fundamental rights, abstractly speaking, to as regards other lower fundamental rights. And these are the rights to life, personal integrity, personal identity, civil capacity and citizenship, non-retroactivity of criminal law, and the right of defense, and freedom of conscience and religion. These are rights, the legal effects of which cannot be frozen. But there's this provision here, other relevant provisions, but there's this provision here that states that the decree that declares the state of emergency needs to specifically pinpoint and identify the fundamental rights, the legal effect of which are being frozen. So there's a degree of specificity that we need to have in the presidential decree. And that is something that did not happen. And I think that it goes according to the Constitution that it did not happen. I don't read the Constitution at face value here. And I think it was good that it was not specific on the identification of all the conditions of time, space, and people, the fundamental rights of which were being, the legal effects of which were being frozen. I will go into that. So the meaning of the freezing of legal effects. I can say that some people are sustaining what I think is a naive conception of the freezing of legal effects of fundamental rights. And they just basically say that there are no fundamental rights if their legal effects are being frozen. It means that there are no fundamental rights whatsoever, which is odd in my view. But they don't explain what does it mean to have no fundamental rights whatsoever. My view on this, instead of criticizing, I will just claim what my view is on this. And it goes, I will get theoretical now. And please, Boyan, tell me I still have a couple of minutes, right?
15.
Okay.
So you have plenty of time.
Okay. So I will go a bit theoretical now. As we know, fundamental rights come from fundamental rights norms. But basically, when we talk about fundamental rights, we talk about fundamental legal positions of citizens. And like Hofold said, I will not go deeply into the conceptual apparatus, but we have two types of rights. We have claim rights. Citizens can demand something and the state is obliged to render some kind of service or good or whatever. And we have liberties. I'm broadly speaking, we have civil liberties, and that just means that we can discretionarily do as we please as regards a certain type of constitutional good, whatever it means. I can freely express myself. I can just shut up. I can do it in whichever manner I am pleased. And what does it mean regarding the state? It means that that is not just a liberty, that is a protected liberty, which is a completely different thing. So the state is prevented, prima facie, I will not go into the conflicts, but is prima facie abstractly prevented from interfering in my civil liberty. So based on this account, if we have the freezing of legal effects of fundamental rights, it depends. If we are talking about fundamental claim rights, then the state is no longer, for this period of 15 days, which is the period that lasts for the state of emergency, is prima facie not obliged to render some types of services and some types of goods. But that doesn't matter that much, because those were not the type of fundamental rights that were frozen. The types of fundamental rights that were frozen were liberties. So that means, in my view, that since we're talking about protected liberties, what it means to have the fundamental liberties, the legal effects of fundamental liberties frozen, needs to be related to the kind of protection that those liberties have. I need to criticize this view. There's a very, sorry for my honesty, very ridiculous view that sees rights as exceptions to this kind of prohibition that is the basis of the system, which is completely inconsistent. Like if we freeze the effects of fundamental rights, we go back to a state of prohibition. It makes no sense, neither legally nor politically. But at the same time, there's another theory saying that, well, if you freeze civil liberties, then you have an indefinition. You don't know the legal status of anything. It makes not even lesser sense, but it makes no sense as well. So I will say that the freezing of the legal effect of protected liberties relates to the government having no longer the prohibition, but the permission to interfere with the civil liberties of the citizens, provided, of course, you don't have the duty to give reasons as you have in the state of constitutional normality, but you have the duty to give some reasons, at least, for going into the scope of the civil liberty. So this is the first and the most long feature or topic that I would like to address. The second one, it follows from this. So you see, if I am saying that freezing the legal effects of fundamental rights means affecting the protection of the civil liberties, that also means, that entails that the decree, the presidential decree that froze the protected aspect of liberties, acted at the constitutional level. So it amended temporarily the constitutional regime of the protection of civil liberties. And this made me wonder. I thought about the concept of norms of competence sustained by Kelsen, and hierarchical norms sustained by Kelsen and developed by Riccardo Guastini. And it goes along the lines of this. If you have a norm of competence, such as the one that we have in the Portuguese Constitution, stating that the president is competent to enact a decree of state of emergency, and the effect of that is affect the protection of civil liberties acting at the constitutional level, then it follows that the norm of competence needs to be higher than the product of of the exercise of that competence. Because the norm of competence under Kelsenian conceptual apparatus is a norm that states over other norms that will be enacted or affected by the exercise of that competence. So in my view, and I'm thinking about going deeper into this, that logically entails that the president, even though he has a constitutional provision granting him the power to affect the protected liberties of citizens, actually is exercising something that is at least presupposed logically as a supra-constitutional competence to affect fundamental rights. I don't know if this is correct. I would like to have your view on this, because this is something that, even though it's theoretical, might have a big impact on the reading of the system of government that we have in Portugal. The third aspect also relating to this is the following. Like I said before, we have certain requirements in the Constitution regarding the decree that declares the state of emergency. Some of those requirements are of legal precision, and we have a law also, a parliamentary law enacted regarding the state of emergency. Some of those requirements are of constitutional precision, and this, of course, is something that needs to be understood, because we have an authoritarian regime prior to the democratic regime, and so the constitution is very friendly, and it needs to be very careful and very precise when restricting or freezing the legal effects of fundamental rights. And I think this is something that, curiously enough, might work the other way around. And this is what I want to say to you. The example, for instance, is if you have a policeman using a gunfire, a fire weapon, we have some regulations on the proportionality for the use of fire weapon. You will see the metaphor here. If you're saying like the policeman, the policeman is using a fire weapon, so he needs to be very cautious as regards the proportionality. He needs like to shoot to the air first and then shoot to the legs and see if the visibility is good. And I'm completely against police brutality, of course. This might also work the other way around, because you do not give him, the policeman, the possibility to have a dynamic protection of fundamental rights. So you need to weigh, on the one hand, the requirements of precision for protecting the fundamental rights of the suspect, that could be the burglar, but at the same time, you need to grant him also the discretion to a certain extent to be able to protect the one who is presumptively being jeopardized by the burglar. So you need to weigh both. It's not just a very naive view that you need to be very narrow and precise on the one hand, but not on the other hand. So what happens here is a lot of people, a lot of scholars, some of them very dishonestly, in my opinion, criticizing the fact that the presidential decree did not specify to the fullest extent and requirements of space, time, and action and people, the fundamental, it did list the fundamental rights that were being frozen, but it did not list the requirements and the conditions fully. And I am afraid, actually, that constitutional issues could arise because we have a provision in the Constitution, separation of powers, it's number 2 of Article 111, saying that no sovereign body may delegate its powers in another sovereign body unless in cases and terms expressly foreseen in the Constitution, which logically makes sense. If you need to have a provision to delegate power, if you don't have a provision to delegate power, you cannot delegate power. So what we had here was some kind of normative delegation. The president delegated to a certain extent the power to fulfill, to specify the conditions for the freezing of legal effects of the fundamental rights by the government. And in my view, it rightly did so because the government has administrative apparatus, the power and the system and the structure and the people to go around, see what is required for a certain situation. And if it happened the other way around, we would have like this president alone ruling without knowledge and capacity to know in which situation the fundamental rights would be frozen. So this is just to let you know, I have a theory behind this, of course, but I do not read the Constitution at face value here. I understand that the government also has the duty and is expressly foreseen in the Constitution to protect the fundamental rights, also not only in a static view, but also a dynamic view. And that kind of conflict, so this norm that I stated enters into a normative conflict with the duty that the government has to dynamically protect the fundamental rights. So this arrangement, in my view, I don't know if it was on purpose or not. I cannot tell you that it was on purpose because I know nothing of what happened factually, but it was, in my view, the right way to conduct this business. And the last issue that I have to discuss with you in the final minutes is the one that is being lived today. So the president decided that this was enough. We're having good rates on the increase of COVID-19, and the state of emergency was jeopardizing economy and other aspects. So both the parliament and the president and the government agreed, well, at least the president and the government agreed that it was time to put a stop to the state of emergency. The thing is, if you do not know, and this is a drama that we're living, in my opinion, if you do not have a strong and clear and precise concept of what it means to freeze the legal effects of fundamental rights, you might go, if you go with the naive conception, you might end up with some of the conclusions that are being sustained in Portugal nowadays, which is the a contrario reasoning, which is being actually deployed in a very improper manner. And it goes like this: if these are fundamental rights, the legal effects of which can only be affected or frozen in a state of emergency, and if you deny the antecedent, you're not in a state of emergency, then you cannot freeze the legal effects of fundamental rights. Okay, fine, but what does it mean? It means that you cannot restrict them, because you cannot have all the fundamental rights at the same time, even if it's in a state of constitutional normality. So the restriction of the scope of fundamental rights, it's just day-to-day business, provided you have the requirements of proportionality and legitimacy to do so, and competence and whatever. So this is being deployed as a political weapon, and I'm not here defending the political party of the government. I'm not affiliated in any kind of political parties, but this is being used as a political weapon to basically sustain that the government cannot, because it is outside the scope of a state of emergency, affect the scope of fundamental rights. In my view, this is completely unsustainable. It's a kind of argument that leads into what it's a slippery slope. I have a lot of criticism to this, but I will just focus on this one aspect. It just bypasses the conceptual aspect of what it is. So you bundle together different things like freezing the legal effects of fundamental rights, balancing fundamental rights, restricting the scope of fundamental rights by enacting laws and decree laws. It goes in the same conception, in the same concept. So everything's mixed up and confused, and you end up with strange conclusions, which are similar to this. Nobody criticized the restriction of fundamental rights prior to the state of emergency. Nobody. Like, the government was being proportional. It was doing without this constitutional provision, which is rather stupid, that we have in our constitution, because it's impossible. We have, this is relevant, I forgot about this, it's my final minute, I will just let you know of this provision. It states that in order to restrict the scope of a fundamental right, you need to have explicit authorization by the Constitution, which is not only unfeasible, it's impossible, because it entails that the founding fathers of the Portuguese Constitution knew it all. So they knew it all, and they decided which restriction was permissible and which was not, which is completely, like, they anticipated COVID-19, they anticipated RGPD, data protection, they anticipated everything back in 76. It's unsustainable. So apart from that, no one was questioning the government. And what it happens is, post declaration of state of emergency, now everyone is very dishonestly saying things that they never cared about before, just because we had a state of emergency in between. And that's very bad, actually. So this was my presentation. Sorry for taking a bit longer. And I hope that we can discuss this, these issues with you. Thank you very much.
Thank you, Pedro. Silent applause. You can imagine it before we give the floor to somebody else. It was a great presentation, a lot of interesting things. I have questions, but I'll give the floor to whomever raises his hand first. And in this case, we have Stefan Rakic with a question. Go, Stefan, the floor is yours.
Hello, everyone. I'm Stefan Rakic from the University of Strasbourg. So anyway, Professor Lopez, thank you very much for your presentation. I won't take too much time in asking my question now, because I'm specializing in the law of European Union. I have I would like to ask you to clarify to me a situation in which, well, you said that Portugal is in the state of administrative calamity. That is something that I don't fully understand, and I would like you to clarify that notion. I would like you to comment, if you can, on what would happen, for example, if for example, freedom of movement as a fundamental right were limited by an act, I don't know, made by an appropriate authority during the state of administrative calamity, especially having in mind the supremacy of EU law established in the Costa versus Enel doctrine, and the recent quarreling between the European Commission and the Germany's Federal Constitutional Court, because the Federal Constitutional Court applies ultra vires doctrine, which the Commission, well, contests, really. And I can see some constitutional issues potentially arising from that scenario. Could you comment on that? Thank you.
Thank you very much,
Stefan. Go, Pedro.
Okay, thanks. I was afraid that someone was going into that EU versus constitutional aspects. Okay, first things first. What does it mean to be in a state of administrative calamity? It basically means to apply a legal regime of administrative calamity. That's what it means. And I didn't intend to say that it was a situation. It means applying a certain regime. That is thought, as some people say, but we never know what it was thought for. It was thought for other things rather than a pandemic. But basically, it means that the government has, by administrative regulation, by the regulation of the Council of Ministers, the power to restrict the scope of fundamental rights. So, but this relates to what I said before, and this is why I need to go a bit further on this. We have a view in Portugal also that needs to be read politically, because we had an authoritarian regime before, that you can that you can only restrict the scope of fundamental rights by law or decree law. And this is false. Not the rule that is false, because rules cannot be false, but the situation doesn't go like that. because you have a lot of regulations restricting the scope of fundamental rights. So what you have here is, again, a conceptual aspect. Some people say, that's not restricting, that's just conforming or concretizing, specifying, expliciting, or whatever. Which is basically the same thing. It's a Sorrentian thing. Like it's the quantitative aspect of a restriction that matters, not if you call it this or that. So the state of administrative calamity is a regulation, not only one, but it relates to a bundle of regulations that provide the government, also the Ministry of Health in a different regulation outside the state of calamity, but it's linked, to take all the appropriate measures to face a state of calamity. So it grants huge discretion. And people are criticizing the constitutionality of those statutes. Nobody cared before. Everything was fine before. Now that you need it, and that you have scientific consensus about the fact that you need it, now they're criticizing. So you see why I'm upset. So that's the first thing. The second thing, I have just skim read the Bundesverfassungsgericht decision, and I have my doubts about the soundness of the grounding, but I would not like to go specific into details on that, even though I am very close to that conception that I think that Stefan will not agree to. Perhaps, I don't know, that, well, constitutions are granting the superiority of EU law, so that's something that they can take back. So I don't really base myself on the doctrines of the European Court of Justice, which is basically Juristenrecht, or something that they create, because normatively, I do not dispute the superiority of European law, provided the Constitution has granted that superiority. Of course, that not all of us are Germany, so not all of us can have Zolange decisions requiring minimum protection of standards of fundamental rights, but that's a political aspect, because not all of us are strong as Germany. But the issue is still the same. So this kind of minimizes the importance, not of the European project that I sympathized, but it kind of minimizes the importance of the freedom of movement as being sourced or grounded in European law as opposed to constitutional law. It's basically the same problem for me.
Thank you, Pedro.
Thank you for your question, Stefan.
Let me remind you that you can apply for asking the question by raising your hand, by hovering with your mouse over your name in the list. I have a question in the meantime. I don't see any hands raised. So what is interesting to it's interesting to me, something that you haven't told us much about. You're obviously reacting to something, but I wanted to see the political situation behind your reaction. So yeah, and I understood the point like this. So the state of emergency is over, and as a possibility of restricting freedom significantly, you have this option of administrative calamity, which is quite similar to the option of we have emergency situation as different from the state of emergency in Serbia. And it is also regulated, it's not mentioned in the constitution, but it's regulated by law. And we have these statutes regulating emergency situations, and the statutes give the government the option to restrict certain human rights, like the right of movement, especially in the case of pandemics and similar things. So politically, basically, parties or societies are claiming that you cannot, that the possibility of restricting human rights by any means other than by the means of a state of emergency is constitutionally prohibited. Did I misunderstand? Did I misunderstood that?
No, that's, you want me to give you the political
Sure, why not?
background?
Yeah, I want to hear it. Yeah, yeah.
Okay, so I will be very honest on what is the background of this. I am very upset with what I call constitutional dishonesty. I will not pinpoint scholars because it would not be elegant to do so, but some of those that enabled restrictions that were not constitutionally valid are those that very incoherently now are using as a political weapon the reading of constitution at face value to attack the government that is taking, in my view, appropriate measures. The issue is very difficult because it's a very easy argument that is very persuasive to the general audience. Like if you are this big professor and you go into the newspaper and you say, this is unconstitutional, just read the provision. They're doing something that can only be done in a state of emergency. We do not have a state of emergency. This isn't constitutional. This is authoritarian. It's completely, it's oversimplifying, and it's well, I cannot be, I'm very upset with this. And the thing is, because the issue is much more complicated, what does it mean to freeze the legal effects, and what does it mean to restrict? I have the view that government, in the use of its administrative power, has the possibility to restrict to a certain extent fundamental rights, provided that there are no basic issues or critical issues that divide the society, like abortion or situations that you need to categorize like that, because that needs to be discussed in parliament, of course, those and many others. But you cannot deprive the government of doing so, because that would deprive the government of fulfilling its constitutional mission. And this is basically, so you see, I'm going nuts over here. This is a constitutional lie, because people are forgetting that this always happens. This always happens. You had a lot of restrictions. You had a lot of discretion in restricting fundamental rights. It's the issue of justification, of proportionality. Those are very important and subtle and difficult questions. But the thing is, and this is the important part of it, whereas in the state of constitutional emergency, you have the freedom, the government has the permission to interfere in civil liberties. In a state of constitutional normality, that is, in a state of administrative calamity, which is a state of constitutional normality, the government does not have that permission unjustifiably. He needs to, under requirements of proportionality, show that in order to do so, certain constitutional interests or the way of certain constitutional norms is outweighed by the way of other constitutional norms, and this is something that always happened. And if it is a very relevant subject, of course, it needs to go to the parliament. It should be enacted by law. But how can you even in a pandemic, and this happens all of a sudden, how can you say that the government would just lay back and say, hey, I can't do anything? This is what these people are saying. They're not saying this because it would be ridiculous, but this is what follows from what they're saying. The government would do, hey, it's not my problem, it's the president. Just go and talk to the president or the parliament, do whatever, it's not my problem. So that it's what they want. I don't know.
I thank you. I made it a rule not to have follow-ups, so I'm just giving the word to dear Sampaio, whom I wave at. Go, Sampaio.
Okay, so hi, Boyan. Hope everything's all right with you. Great initiative. Pedro, thank you very much for your amazing presentation. I just have it's a doubt, because you were talking about the difference between restriction and suspension. And when you talk about restriction, you talk about like a kind of a scope compression of the normal fundamental right. And when you talk about suspension, you talk about a kind of freezing of the legal effects or the effects. And my question is kind of what is the exact difference between these two concepts, and can one say that actually suspension is a kind of a token of a restriction, is a kind of affection or a compression of the temporal element of the antecedent of principle of the fundamental rights? And I was like thinking, because all these, when we talk about fundamental rights and restrictions to fundamental rights, and generally in fundamental rights, this is a kind of ambiguous discourse. We can be talking about, as you said, claim rights, liberties, as well as, for example, the correspective duties, the immunities. Maybe what is being freezed is the immunity, like people have, not to see their fundamental rights affected in some way, for example, in a disproportionate way. So they still have and can exercise the fundamental rights, but now I don't know, like the parliament or the government has this power to restrict, for example, suspending during some time in a more disproportionate way the right. Thank you.
Okay, thank you, Senpai, for your question. It's again, maybe it's an immunity. I haven't thought of it in Hofeldian terms. The basic idea for me is that you have no clarity. I don't know if you will have from now on, but you have no clarity on what it means to freeze the legal effects of a fundamental right. I think that it's substantially different from restricting the scope of a fundamental right. When you restrict the scope of a fundamental right by enacting a law, you restrict the scope of the permission that you have. Like you add requirements to the ones that were foreseen in the Constitution, if there were any requirements to the permission. When you are freezing the legal effects of the fundamental rights, you are not restricting the scope of the fundamental rights. You are changing the status of the fundamental rights. You are permitting the government to affect a liberty that is no longer protected. So maybe that's why you linked it with the Hofeldian concept of immunity. I was basically reasoning on what is the purpose of having constitutional liberties if these liberties are not protected. Of course, they need to be constitutionally protected. So it's substantially different, and this is what I think our constitutional scholar friends are missing out on. It's substantially different to restrict the scope of fundamental rights in certain conditions than to amend, to change the status of the fundamental right. Of course that I need to anticipate criticism on this, because of course that the decree of declaration of state of emergency can do both. It might be the case that the decree of the declaration of state of emergency both freezes the legal effects of fundamental rights, allowing the government to affect and interfere on civil liberties, not as he pleases, but with the lowest degree of justification, because it is up to the government to decide when that should be the case. And it could also be that the decree of presidential the presidential decree of declaration of state of emergency restricts the scope of fundamental rights. And that's why I sustain that the decree of the declaration of state of emergency is not a decision per se. It's a decision, but it also has normative effects, because it affects both the fundamental rights norms, and it may also restrict, normatively speaking, for a category of addressees and in a category of situations, the exercise of fundamental rights. Thank you for your question.
The next question is from Nina Krishlianin. Nina, I'll unmute you, but you can do it also.
Thank you, Boyan. I have a question regarding not the effects, but the interpretation of the conditions for introducing a state of emergency. I was now Googling the Portuguese constitution, but it seems that such states are more or less similarly defined in most Western constitutions. We have a very similar situation in Serbia now as you have. So the state of emergency has been freshly cancelled, but we still have an epidemic warning going on and some restrictions, probably, as Boyan already said, similar to your administrative, I forgot the phrase you used, administrative calamity, yes. The question I have is, there is a number of medical experts around the world who are warning against lifting the measures against the pandemic too soon, and they are warning that we might have a second wave because just as the risk is dropping below a certain level, the states are abolishing their states of emergency and people will come out again and start socializing, although they are warned it's better not to, but they are no longer prohibited to, and then again the virus will spread and we'll have a second wave. What do you think? Is it justifiable? Would it be justifiable in such conditions for a state to say we will keep the state of emergency a while longer because although the risk is not so great right now, it might increase if we no longer have a state of emergency?
Thank you very much. It's a very, very interesting question, and I'm afraid that I will not be able to cover all its extent. But the first aspect that I would like to say is that you're right. It's a fundamental aspect to see the interpretation of the requirements and the purpose, because the Constitution states the purpose of the declaration of state of emergency. So we have a conceptual problem again, because one of the requirements is a state of calamity, and now you can say this is the confusion. This is a complete mess. Well, it's not the administrative state of calamity. It's a factual state of calamity. And this has, all the people are mixing this up, meaning that it could mean the same thing. It's not, of course. So you can only have declaration of state of emergency. You have two types of constitution exceptionality: state of war and state of emergency. So state of war is for imminent attack on the country, and other types of calamity which are much more severe than what I would call the normal calamity. And that is the requirement, the requirement for the declaration of the state of emergency. So you have a lot of discretion, of course, to understand what is state of emergency, what is a calamity for the purpose of state of emergency. And many people in Portugal were sustaining that it was not reason enough to declare the state of emergency. Many scholars also were saying we can do with the state of administrative calamity. We need not go into that. But what's the purpose? And this, I think, links to Nina's question. The purpose is to get back as soon as possible into a state of constitutional normality. That's the purpose of declaration of the state of emergency. It's an exceptional legality, the sole purpose of which is to get back as soon as possible to a state of constitutional normality. So again, there's a lot of discretion here. One could say that that's the whole reason why you have a fixed term of 15 days of declaration of state of emergency that can be renewed as necessary, and it was renewed twice, and it can be renewed for a while longer. And that's the issue here. Some people were saying, and I think this was your take on that possibility. Some people were saying, listen, let's just keep the state of constitutional emergency, but keep it to a minimum. Like, I don't know if the purpose was to be symbolic or advising, but that's just going back into a state of administrative calamity or something of the type. But many people were saying this might send the wrong message, so maybe you should exercise the power to declare the state of emergency, but then keep it to a minimum or delegate everything to the government. Okay, so what's my view on that? I would need the facts, of course, and it's a matter of decision, political decision as well. So I'm not in the best shape to make that kind of decision. But what I know is from a constitutional standpoint, that declaration of state of emergency to a minimum, delegating all the powers to affect the status of fundamental rights to the government, that would be too much in my view. That would be unconstitutional, because that would be a complete delegation of powers, not the one that we had in our presidential decree of declaration. The president gave some requirements and then delegated to the government. So we had like requirements there, and we had purpose, meaning and purpose. It was not blank. It was not a blank check. But my view, even though I tend to guide myself by science on these matters, so I'm terrified with people saying that this is nothing whatsoever, people having some kind of strange faith that this will go away by next Monday. And we have those people. I think every country has those people. I think that that's the wrong way to go about it. But I think that the Portuguese government, has been very proportionate here. I will go into the political aspect now, but they did. Okay, so we are no longer in a state of constitutional emergency, but we took this step together with the president. But if required, we will go back into declaration of state of emergency. It's not hell, as we know. It could happen again, and if necessary, we will go back into that. But we'll just be proportionate here. We will restrict to the ultimate necessary purpose, the scope of fundamental rights. We will lift the constitutional emergency because we need to have the economy back. And this, again, it's something very important. You cannot go in health versus economy, because economy is health as well. So it's a very complicated issue of incommensurability. You need to weigh both and have a proportionate decision. So I tend to agree with the facts that I have, that the constitutional emergency, the state of constitutional emergency was raised, but I feel very comfortable that either the president or the government accept the possibility of going back into that if we have an increase of death or transmission of COVID-19.
We have two more questions and a 1 hour time frame, so please keep it brief, both in terms of questions and in terms of answers. The next question is from Pedro Azevedo. Go, Pedro.
Boyan, I don't mind skipping mine to give the chance to other one.
Go. We'll have it both.
Okay, trying to be really fast, Pedro. Of course, we can have. Can you all hear me?
Yeah.
We can have restrictions of fundamental rights by regulation. That seems obvious. I agree with you. And regarding some premises of what you said, that the sovereign bodies should kind of cooperate in this type of matters, and considering that we first started in the state of emergency, there's something that worries me. And I'm realistically speaking, I'm very comfortable with what's happening, but legally speaking, we are basing a decision of the government, a decree law, that is based on some laws from 1980, 40 years ago, 35 years ago, and you said yourself, the legislator couldn't have known it. And that decree law, that regulation is getting its force from two laws, which I have most doubts that apply to this case, because they are just normal civil protection law, and all of them, those two laws, are competence from the parliament, so they can only be enacted by the parliament and not by the government. So what I see here is the government getting a free check as to I go to the law that has 40 years and I get a free check to do everything I want to do. In Spain and France, for example, I think they did a new law regarding the pandemic, kind of a pandemic law, kind of a framework law that would allow me. Don't you think it inverts a little bit? It gives the power to the government to do whatever it wants based on a law that doesn't even apply here, in my opinion.
Thanks.
For the rest, I loved it. It was amazing.
Okay, thanks. Okay, thanks. I will focus on one aspect to give you again context on this. Some people are saying, I'm not saying that Pedro is saying this, but some people are saying that the government is trying to run away from the parliament, not presenting a decree to be enacted as law, because the government doesn't have the majority to, by itself, pass the law. So people are saying that the government is being less democratic because they should. This is relevant enough, even though that I don't think the law is 40 years old. But that's not the issue here. The issue, very interesting issue that Pedro was saying is, can we accept the fact that the government is choosing regulation to avoid political confusion and commotion that would maybe prevent the government from enacting the law that it should enact in parliament, because the opposition would have a different idea and that you would have a political issue out of a public health issue. Yeah, it's very hard because my constitutional law background would advise me, of course, to say, yeah, the right way to do this. Okay, so we've gone through like the epicenter of the storm, and now we need a law about this. So you should go to the parliament and enact a law. Okay, that's fine. I will stick to that. But you have to connect this, and again, I stick to that, but you have to connect this to what I said before. A lot of people, not only scholars, actually the opposition is behaving incredibly, like cooperating with the government in a manner that I think it's really, really exceptional. I would not expect otherwise, but I think that it's behaving incredibly. But would the government risk having those kind of people that are using constitutional arguments? And some scholars have a very relevant political weight. Would the government risk that, turning a public health issue into a political issue? That is a political decision. That is a political move of the game. I do not subscribe it from the constitutional standpoint, if you do understand me, but I'm so upset with what some people are saying. And the other day, 2 days ago, it made me wonder. It made me wonder, and I thought, oh, okay, it's because of these guys that the government is trying to run away from parliament. It's not good, because these are the ways that, that you reduce parliament to a minimum, and it's democracy. It's not good. But I will go as far as saying that it's a bit understandable.
We have our last question from Gonzalo Fabiao.
Hi to all. Can you hear me?
All my Portuguese friends are asking questions.
Hi, my name is Gonçalo Fabião. I'm from Portugal in University of Lisbon, and I have a question regarding again the distinction between suspension and restriction or limitation, because from my perspective, if we regard restrictions as restricting a fundamental right in the name of a constitutional interest, and if there is only a state of emergency that allows you to interfere in fundamental rights in the name of another constitutional interest as well, and if all regarding restrictions, you have to do so proportionately, as well as you also have to do regarding the state of emergency. What is the main difference between the two? Is it a question of burden of argumentation? Is it a question of having the ability to enact some kind of competence norm that allows the government to interfere in fundamental rights that couldn't be interfered with by the government by itself? That's it. That's the question.
Thank you, Gonçalo. I think I kind of addressed it earlier on, a part of the question, but it gives me the chance to be more specific. Whereas you have constitutional norms like conflicting with one another. And of course, this is kind of strange in Portugal because a lot of constitutional scholars think that constitutional norms very scarcely, very rarely conflict with one another. They have a coherentist view. Of course, it means that they have the reading of the constitutional norms that pleases them, and that's a matter of interpretation. Very kind of not transparent interpretation in my view, but you have constitutional norms conflicting with one another. It's day-to-day normality. My view again is if you have a declaration of state of emergency, then the president is exercising normative power at the constitutional level that changes the prima facie prohibition to affect the fundamental rights. It's only prima facie because it means that it might enter into a conflict, and all things considered, in a state of constitutional normality, you might need to affect the fundamental rights. So it changes that prima facie prohibition into a status of constitutional permission or liberty from the government to define the conditions of affecting that fundamental right. This is just scratching the surface, of course, because this has a plurality of consequences, which I'm thinking of now, and I've only thought of some, and I'm not quite sure of them, but it also links to the degree of the burden of argumentation that you need to bear to justify interfering with the constitutional rights. So the normative aspects of the presidential declaration of the state of emergency not only affects the status of the fundamental rights norm and the powers of the government, it also makes it so that the government has not a plain power, but it's like he's winning the game from the beginning. Like it can be outweighed, but all things being equal and all things being normal, he can just interfere with civil liberties because he is in a specific situation in which he is calling the shots on which would be the requirements for affecting the civil liberty for 15 days. So you see, it's granting. That's why, in a very classical manner, we say that in a state of constitutional emergency, we are granting extra powers to the government. The government is like summoning all the powers and calling the shots. I think my constitutional interpretation of this is that the government will have discretion with very limited counter-argumenting on which are the requirements for interfering with civil liberties. That's the substantial difference.
Oh dear, you're in for a surprise when we have this session about Serbia. It was a great talk to see what you can and cannot do when it comes to powers in an emergency state. Thank you for a great presentation. Thank you all for participating. Next week, Thursday, Pedro, it's not that just your Portuguese friends ask questions. They asked most of them, but I'm quite sure that almost everything that you said resonated quite strongly with all the listeners from Serbia and other places, because the situations are quite similar when it comes to regulation, but also different when it comes to the enactment of states of emergency and the realization of state of emergency and the limiting of human rights within states of emergency. Of course, we'll have accounts from other countries, but this was a great account from Portugal, and I was very glad to hear it. And next week, I invite you all to come again. It's still Thursday at 6 o'clock Belgrade time. Matthias Gurk, who is also with us here, maybe even now, I can't see it. Yeah, Matthias is here. We'll be talking about the state of emergency in Slovenia. So we'll look forward to that. Thank you, everybody. And until next week. Thank you once again, Pedro. Bye.
Very much, Boyan. My pleasure. Thank you, everyone.
Thank you.